What is a tenancy at will? Have you ever wondered what it means to have a tenancy at will? This type of property arrangement is quite interesting and important in real property law. A tenancy at will occurs when a tenant occupies a property with the landlord's permission, but without a formal lease or fixed-term contract. This means that the tenant can stay on the property as long as both parties agree. One of the key features of a tenancy at will is that it does not have a fixed duration. This means the arrangement continues indefinitely until either the landlord or the tenant decides to end it. Unlike a traditional lease, there is usually no written agreement. Sometimes, there may be an informal understanding or even an oral agreement between the parties. Both the landlord and the tenant have the right to terminate the tenancy at will at any time. However, they typically need to provide reasonable notice before doing so. This notice period often ranges around 30 days, but it can vary depending on local laws. Even though there is no formal lease, tenants usually pay rent on a regular basis, such as weekly or monthly. This payment structure helps maintain the landlord-tenant relationship, even in the absence of a formal contract. Tenancies at will often come into play after a lease has expired but before a new lease is signed. They can also be useful for parties who prefer a more flexible arrangement without long-term commitments. From a law school perspective, understanding tenancy at will is essential for bar exam preparation. It is classified as a type of possessory estate in real property law. Unlike other types of tenancies, such as a tenancy for years or a periodic tenancy, a tenancy at will lacks a fixed or periodic term. Practical considerations are important as well. Although either party can terminate the tenancy at any time, most jurisdictions requiring reasonable written notice. This means that both landlords and tenants should be aware of their rights and obligations. Tenants at will may have fewer legal protections compared to those under formal leases. However, local laws often impose minimum standards that landlords must follow. It is wise for both parties to understand the risks associated with such informal arrangements, including the potential for sudden termination and unclear rights. In summary, a tenancy at will is a flexible and informal arrangement that allows either party to end the tenancy at any time with appropriate notice. This concept is significant in real property law and is relevant for bar exam review, helping you understand various landlord-tenant relationships and their legal consequences.